So how do you know what is right for you? And it's not quite a trick question, but put it this way. Even if you are the person who will correctly administer your trust, you'll set it up, you'll do all the work, you'll do all the maintenance. When you die, you're not in charge. You're relying upon the successor trustee to do what they are supposed to do. And if you have complete confidence that they will seek legal help, that things will be done correctly, then you might want to consider a revocable living trust. And if you don't need to protect your surviving spouse and put that nest egg away for them so that they would be able to receive the state-based pay for any long-term care, then a revocable living trust might work for you. I do want to also mention that these kinds of trusts aren't just for your spouse. Maybe you have a special needs child, or maybe you have an adult child who has lifestyle issues, or maybe your adult child, you're worried that they're going to get a divorce. So maybe you want your children to inherit from you, but to do so in a protective mechanism, not outright. The protective mechanism is a trust, and you can set up a trust for those who inherit from you through your revocable living trust, through your will. Both of them work. If you set it up through a revocable living trust, again, we have to make sure that your successor trustee does their job, gets the legal counsel that they need, which is more assured if you set it up through a will-based estate plan. Both of them work, however, assuming that people do what they're supposed to do and get the legal guidance they should get. So inheriting in a protective trust can be done either through a revocable living trust or a will, except for when it comes to your spouse. If you want to protect that money for your spouse against long-term care costs and to be able to obtain Medicaid eligibility, you can't use a revocable living trust. You must use a will. What's right for you? It depends on your circumstances. It really does. Just keep in mind that here in Washington, probate is not that terrible, awful type of thing that you hear about. It's not based on, the cost of probate is not based on the value of your estate, unlike some jurisdictions that take a percentage. The legal fees are based on a percentage of the size of the estate. That's not how we do it in Washington. It is based upon how much time is involved and how easy or difficult is it to probate. With a good estate plan, you're far better off than if you have no estate plan. If you use the attorney who drafted your will, there should be some efficiencies there as well in the probate because they know you, they know what the plan is. So, when it comes to what's the best for you, take a look at yourself, take a look at your situation, and then in addition to listening to educational information like this, reach out to an estate planning and elder law attorney and get that counsel, that legal guidance that will make sure that you get the right estate plan for you.